Hi friends, Josh Yeager, fiduciary governance captain. Here on another walk and talk about fiduciary governance. Duty today that we're going to talk about is the duty to prudently select delegatees. So when you're a trustee and you've got some responsibility that you're not really competent at doing, best practice would be to find someone that is good at that thing and then delegating responsibility to them. And then you want to be clear on why you selected the people you selected. So in this case, we'll talk in the context of the investment advisor that the trustee chooses. That may be friendly folks at Merrill Lynch or Wells Fargo. Those are brokerage firms. Or perhaps a registered investment advisor that you chose from your town that manages the capital through Schwab or Fidelity. And we've got to answer the question, create a record. Why did you choose who you chose? And my experience is that the trustees don't typically have a very good answer for this, other than things that wouldn't appropriately go in the governance file. Like I went to school with him. I think he's a great guy. Always returns my phone call. The family, before Grandpa died, really trusted him. And those are interesting reasons, but not fiduciary reasons. Holy cow, check this out. That's pretty sweet. So we'll kind of think through the things that you'd want in the governance file of why the investment advisor that you chose was prudently selected. One good reason would be they got the license to do the work that they do. So that'd be going onto the FINRA site, looking for the broker's name, making sure they have the license by FINRA and SEC to do this kind of work. Another reason might be the years that they've been in the business. Probably isn't a great idea for a trustee to select the management of the trust assets or delegate the management of the trust assets to somebody that, you know, is 2 years in the business. Want someone with some tenure, has some experience. Another reason might be any additional education that the investment advisor had, CFP or CFA or any of the other list of chicken soup letters that go behind the investment advisor's name that demonstrates they've got additional credentialing education. Another factor might be the investment advisor's ability to identify a target rate of return and a level of risk. Those obviously are things that a trustee is responsible for doing. So if the investment advisor is unable to manage towards a return objective or a risk expectation, it might disqualify them. Now, of course, we're not going to assume that they're going to get those outcomes every year, but they at least need to understand that the trustee's responsibilities are to establish those things and they're willing to manage accordingly. Other factors that might go into the selection of the investment advisor might be the it's a beautiful lighthouse behind me. So great. Might be the investment advisor's understanding of the key elements of the Prudent Investor Act and modern portfolio theory. Those are the things that the Prudent Investor Act is based on. Other factors might be the investment advisor's willingness to provide the trustee documentation around the management of the trust. There are particular reports that the investment advisor needs to produce, and being able to say, yeah, I understand, trustee, that you have these duties and responsibilities. You're not just another rich doctor. You owe responsibilities to somebody else, and I'm willing to help you document the fulfillment of those. Another might be being willing to write down their advisory fee and have it clearly documented so the trustee could measure against that in the future. That's a list of the main factors. So imagine a trustee is able to create a record that says, yeah, I've chosen XYZ investment advisor. He's been in the business for 15 years. He's got the appropriate licensure. He is familiar with the key tenets of modern portfolio theory. He understands that I have reporting responsibilities to a third party. is willing to help me generate reports annually that fulfill those duties. He's got additional credentialing as a certified financial planner, or has an MBA. CFA has some additional educational experience. They presented a thoughtful investment process that was informed by my return objectives and risk expectations. They've clearly stated their fee in a way that can be reviewed annually. They've affirmed their duties to me, that they owe me, the trustee, a fiduciary duty when they're providing advice to act only in the best interest of the trust. That kind of narrative would be great. Now, we know practically the reason the trustee's hiring them. They're hiring because they're good guys that return phone calls and the family's comfortable with, but those aren't the kind of things that go in the record. The things that go in the record are the things that demonstrate that the trustee has been prudent when selecting this particular advisor. So that ends this duty of care, the trustee's duty to prudently select. Follow-up duties are the trustee's duties to clearly and prudently delegate responsibility to this agent. And then the last is the trustee's duty to monitor the agent's activity, and those items will be covered in follow-up talks. Thanks, folks. I think you're great.